Good afternoon, everyone. We'll call this Governance and Priorities Committee meeting to order. Welcome to the June 26th Governance and Priorities Committee meeting. I'd like to first recognize that we are on the traditional territory of the Nanaimo First Nation. Our clerk today is Ms. Sheila Gurry. Today's Governance and Priorities Committee meeting will be held in accordance with the Community Charter and the Council Procedure Bylaw 2018, number 7272. The question period sign-up sheet is on the table by the double doors to my left for agenda items only. If during the meeting any member of the gallery has a question regarding an agenda item, please write it down your name and the agenda item on the sheet. Members have been granted the authority to join meetings electronically. And we have Councillor Brown, who's on Zoom with us. Thank you so much, and Councillor Armstrong. Today we have the agenda will be started by going through late items with Ms. Sheila Gurry.
Thank you, Chair. There are no late items for the agenda this afternoon.
Okay, if I could please have a motion for the adoption of the agenda. So moved by, it's so funny, it's just such a different role. Councillor Thorpe, and seconded by Mayor Krogh. All those in favor? Carried, thank you. And the adoption of minutes, there are no minutes today, so we'll go right into the agenda planning with talking about the upcoming topics and initiatives by Sheila Gurry. Thank you, Sheila.
Thank you, Madam Chair. On page 4 of your agenda package is the upcoming topics and initiative sheet. We have today's meeting topics noted, as well as there was a couple additional items that were scheduled for today. They have been moved to other meeting dates in the future. And for July 17th, we tentatively have scheduled the City of Nanaimo Communications and Engagement Plan, Systems Planning Organization, the SBO Work Plan Strategy, Downtown Parking, Transit Stop Amenities, Pedestrian Unallocated, and Extension Road Traffic Calming. Then for July 26th, we tentatively have scheduled the Public Safety Committee Terms of Reference, City Plan Monitoring Committees, and BC Energy Step Code and Zero Carbon Step Code implementation. Then, as noted, there are no meetings scheduled for GPC in August or September. So the next meeting in October, we have some tentatively scheduled topics as well as the November GPC meeting. So if there's any questions and or concerns, or any members of the committee have any questions for me, that'd be great.
Are there any questions by council? Okay, I'm seeing none. Ms. Gurry, we'll go on then to the next reports. First one is under Ethics Commissioner Appointment Options, and you'll introduce this for us?
Yes, thank you, Madam Chair. I will turn it right over to Ms. Robertson, Deputy City Clerk, who has spearheaded this initiative since the get-go back in 2022. So she'll be talking today about the Ethics Commissioner Establishment Bylaw that was in effect on October 15th, 2022, and some of the options moving forward of actually having that position established in the framework of the bylaw. So I'll turn it over to Ms. Robertson before I say something wrong.
And Ms. Robertson, just before you start, I just wanted to say that we have Mr. Reese Harding from Young Anderson Barristers and Solicitors in attendance by Zoom. Thank you for being here, Mr. Harding. As you can tell, this is my first time, so if I miss you, just scream in the background. I'll catch you eventually.
Yes, thank you, Madam Chair. You're doing a great job. Thank you very much.
Thank you. Ms. Robertson, I'll let you take it from here.
Thank you. Good afternoon, Madam Chair and Council. As noted in the report, Council adopted the Ethics Commissioner Bylaw back in May of 2022, and this is actually a companion bylaw to the Code of Conduct Bylaw, wherein any informal or formal complaints made for violations against the Code of Conduct Bylaw would be investigated by an Ethics Commissioner. So the Ethics Commissioner is defined as either a commissioner that's appointed by Council, or in the absence of appointing a commissioner, the definition defaults to what is called an ad hoc commissioner or a third-party investigator. So in either case, though, the individual, whether appointed or not, would be the one to conduct any of those informal or formal complaints made, and also be the one to conduct the investigations. And these individuals are typically lawyers, or senior investigators that have the necessary municipal, legal, and judicial experience to investigate those complaints. And also, whether you formally appoint a commissioner or you retain the ad hoc commissioner model, Their services would only be used on an as-needed basis. This would not be a full-time position like they have in Surrey or Vancouver. So when the bylaw was adopted last year, staff had outlined in the financial implications section of the report that should any complaints arise, given the narrow scope of Nanaimo's bylaws, that it should be able to be absorbed within council's existing legal budget. But, and I'm really happy that to date, since the bylaw has been adopted, there's been no informal or formal complaints that have arisen. Having said that, the legal budget was reduced by about $50,000 for 2023, so there would be very, very little wiggle room should a complaint arise in the future. So when council passed the motion back in March directing staff to prepare a report on the costs and the potential selection criteria should they wanted to pursue appointing a commissioner, staff once again reached out to Rhys Harding for his advice and guidance based on his experience as Surrey's Ethics Commissioner on his thoughts on what an appropriate budget as a starting point would be based on a few options ranging from retaining the status quo model that we have right now, or whether we would go to a limited ethics model, which would be option 2, or more of a month-to-month commissioner model, which is option 3. So what I'll do is I'll just provide a brief overview of each of the options, but no matter which one is selected, council should look to allocate some funds in the 2024 to 2028 financial plan in the event there is a complaint that needs to be investigated. So the first option, which I mentioned, was the ad hoc commissioner model, and this would be selected if council just wants to retain the status quo, what's going on right now. This means that should a complaint be filed, a third-party investigator that has the legal, judicial, or quasi-judicial experience would be selected, and this is based on a list that would be provided by our legal counsel through the CAO to investigate the complaint. If we had a few complaints in the future, it could be the same individual that investigates them, or it could be a completely different individual. It would all be based on availability. And because it's impossible to predict how many investigations we might have in the future, Mr. Harding suggested that about $100,000 be allocated, as a challenging investigation could run upwards of $40,000. Also included in this option are funds to conduct 4 one-hour digital seminars with council on matters such as governance or conflict of interest or whatever topic is appropriate. And this was included as Mr. Harding conveyed to the previous council that the success of the code often comes up to upfront education and strong communication. So having those sessions would really help to support the code's success. So the total budget proposed for this option would be approximately $107,000. Under option 2, council would be signaling that it wants a bit more of a consistent commissioner presence, wherein council would want the same individual conducting any investigations, also there to provide advice and conduct the training sessions. And in doing so, council would then appoint an individual as its ethics commissioner. As noted earlier, though, even formally appointing a commissioner through this option, the city would still be only utilizing their services on an as-needed basis to investigate, as it relates to investigations. This option also, again, the same 4 one-hour sessions as would also be recommended. The one thing that was added in this option, though, is a way to promote the relationship between council and the ethics commissioner, whereby 3 phone calls per month at about a half an hour each would be budgeted for, so council could just simply pick up the phone and discuss any concerns that they had about conflict of interest or questions around it or questions about the code without having to go to council for approval. Because currently any requests to receive advice on conflict of interest must be managed through the council spending and amenities policy, where you would need council approval via a resolution. A potential disadvantage to this option is that should a complaint arise and the ethics commissioner find that there was a violation and there were sanctions being recommended, that relationship between that particular council member and the ethics commissioner could be a bit strained in the future. So the ad hoc model is a little bit more impersonal, so there's pros and cons to both. The total budget for this option is proposed to be $115,000, so not a lot more. Option 3 would be considered a more enhanced month-to-month model, whereby up to 5 phone calls would be budgeted for, and instead of 4 one-hour digital sessions, the Ethics Commissioner would attend those sessions in person. So it would promote an even deeper relationship model. So in the event that Council wanted to formally appoint a commissioner, and that would be through option 2 or 3, staff looked to Surrey and Vancouver to see what their recruitment process and selection criteria was, as they are the only 2 municipalities in BC to actually have formally appointed commissioners. Surrey developed a selection committee, and it was comprised of council members, a lawyer, and members of the public. And they basically administered the process and made their recommendations to council. Vancouver utilized the services of an executive search team to assist them. So staff also took a look at their terms of reference in their ad, and it became clear pretty quickly that the recruitment processes that they used would really only be applicable if a full-time ethics commissioner was being considered, where a full-time office was being set up as a function within the municipality. And given their size, and given that in their bylaw they include members of the public in their bylaw, it makes sense to have a full-time role. But because Nanaimo's Code of Conduct, the scope is narrower, and given that we would only be utilizing the position on an as-needed basis, there wouldn't be the need. Like, the process just doesn't make sense in that case. So really, it comes down to what the hourly rate would be for that individual to provide guidance to council via telephone calls, to conduct the seminars, whether they are digital or in person, and to conduct any informal or formal investigations. And in doing so, one would want to make sure that the individual has the right legal experience necessary to conduct those investigations. So you would want to target them specifically, the ones that have the expertise. So staff would recommend that we do kind of a similar process that we followed when we were going through the process of selecting who our municipal law firm would be, and that is that you solicit the various firms with the specific experience. You provide them with the selection criteria, which I've outlined in the staff report, and then you would simply seek out the best rate, ask them to bid on what the rate would be. So based on this information, staff put forward 3 options for consideration, and either Reese or I would be pleased to answer any questions about any of the options or any concerns, or also if council wanted to provide any alternate direction.
Okay, thank you, Ms. Robertson. Mr. Harding, did you want to add anything to the discussion before we go on to questions?
No, I don't think so, Madam Chair, only to say that I think the options set out by Ms. Robertson and her team are worth considering, to the extent that they really draw, it's a bit of a binary choice, stay ad hoc or look to develop a bit of a relationship with an individual. Only thing I'll say, and I agree with all of the direction from Ms. Robertson with respect to her commentary. I just want to make it clear, though, for Mayor and Council, that there's no misunderstanding with respect to Surrey and Vancouver. Certainly the Ethics Commissioner's offices in those municipalities are more robust. Ms. Robertson is absolutely correct in that regard. Larger cities, bit of a broader code, but I don't want anyone to think that the Ethics Commissioner is in-house at either of those municipalities. They're not. They're external to the city's process. They're just probably given much more, shall we say, responsibility than you would in Nanaimo, given the narrowness of your code and the size of the municipality by way of comparison. So both ethics commissioners in Surrey and Vancouver are external lawyers to the city. So I just wanted to make sure that was clear. That's all I have to add. Thank you.
Well, that's great. Well, we'll start then with questions. We'll start with Mayor Krogh, Councillor Manley, and then Councillor Armstrong. Councillor Manley first. Sorry. Thank you.
I think I just shut my mic.
I think it's okay. I'll find you right here. Hold on. There you go.
It was on.
I turned it off. It's okay. You should be on.
Thank you, Chair. Appreciate you getting
I'll get this.
your learning up and
That's
going
right.
on the device. Yeah. So when I was reading through this, I think probably for me, I'm thinking that option 2 or 3 would be preferable than having, just given the history that we've had here, having the CAO appoint a ethics commissioner in the middle of something happening might not be the best option. But when I was going through the material, I noticed that we would be looking for a firm. not necessarily a person. And so if we were working with a law firm, they might have different people that took on the role at different times. Is that correct? Or would it always be the same person from the firm that would be engaged to be the ethics commissioner?
It would be the same individual. I don't know if Reese has some additional comments on it, but that would be the individual that was selected. And if by chance they happen to be the same firm that provides us with other legal services, it would be kept very separate. And Reese could probably speak to that as for when you were representing Surrey.
Yes, through you, Madam Chair, to Councillor Manley. Normally, an ethics commissioner is appointed as an individual. Usually it's a person that's appointed. And again, we've got a pretty small sample size here, right? I mean, there's been 2 ethics commissioners for Surrey and 1 for Vancouver. So individuals are appointed that work within law firms. And I can tell you from our experience, I was appointed as ethics commissioner, but I had a team of people at my firm that assisted me with investigations and other matters. So it was certainly not one person doing it all. For a municipality of that size, that's not really doable, really manageable. So in a sense, you're on the right track. You're appointing an individual, but in essence, you're working with a larger team. There's going to be multiple people, I think, within that team that will be of assistance to the ethics commissioner and their duties if the city of Nanaimo were to go with something like Ms. Robertson's option 2 or 3. So certainly it's a bit of a team approach, Councillor Manley, for sure.
And I guess the larger difference between option 2 and option 3 is really having the in-person workshops. And in the past, we've had Don Lindstone do that with us. Don Lindstone has done that with us.
Right.
And I kind of appreciate that approach, to be able to have, conversations rather than dealing with it by Zoom. But it's an added expense, but I think it's worthwhile. So those are my thoughts.
Thank you, Councillor Manley. Mayor Krog.
Thank you very much, Chair, and I appreciate Mr. Harding, you coming today, and I'm not sure you can answer this question. I mean, given the limited experience with this quote-unquote office in British Columbia, is there any guidance from other provinces who are maybe ahead of us in this? Is it common, if possible, to, if you can answer it, to have an ad hoc person appointed, or is it a permanent position like the Conflict of Interest Commissioner is in Victoria, for instance, for members of the Legislative Assembly?
Through you, Madam Chair, to Mayor Krog, there's different models throughout Canada, Mayor Krog, in regard to how ethics commissioners' offices are operating. And I'll give you the one that I'm most familiar with outside of our jurisdiction, and that's the province of Ontario. So in the city of Toronto, for example, they have a full-time functioning office with a full-time employed, I'm not sure if they're an employee of the city of Toronto, but they might be. If they're not an employee, they're probably an officer or something of that nature. It's a robust office in the city of Toronto with multiple full-time employees that are administering not only their code, but their conflict of interest guidelines, et cetera. They have quite a robust process in Ontario. So certainly in the larger municipalities in Southern Ontario, full-time ethics commissioners are not uncommon. In the medium and smaller sized local governments in Ontario, the legislation there requires access to ethics commissioners. They're required to have one ready to go when needed. So it's not an ad hoc decision there. They have somebody that's retained when necessary, but they're not usually employees or full-time staff. They're just there to be used when necessary. So we see a bit of a hybrid modeling across different parts of Canada. I can tell you that the city of Winnipeg has a full-time ethics commissioner who is an external lawyer to the city. I believe the city of Calgary has a full-time in-house ethics commissioner, and I believe a conflict of interest commissioner as well, as I recall. City of Regina has a external ethics commissioner that they rely on. In Quebec, there's a provincial office that oversees municipalities, so it's a very different system in Quebec. But generally speaking, there's a bit of a hybrid hodgepodge across Canada with respect to how local governments are engaging ethics commissioners on either a full-time, part-time, or hybrid basis. So what Surrey and Vancouver have done in British Columbia is probably not out of line very much with some of the other larger municipalities across Canada, perhaps but for Toronto. Toronto, I think, is an exceptional situation. I don't know if that helps, Mr. Mayor.
Thank you very much.
Thank you, Mayor Krogh, and on to Councillor Armstrong.
Thank you. My preference actually is option one, and that's based on the previous 2 terms I've served on council, especially having read numerous reports from different individuals and different law firms. They were all different qualities, as well as I believe it would serve us better than having one individual that could build relationships with certain individuals. So for me, my preference is option one, and I don't know if Councillor Thorpe would comment further on that based on his experience as well. Thank you.
Thank you, Councillor Armstrong. I'm just waiting for any other comments or questions. Seeing none, then the wish of, I'm sorry? Oh, sorry, Councillor Thorpe. I'll get this, I promise I'll get it. Thank you.
Doing great. Thank you very much, Chair. First, to answer Councillor Armstrong's comment, I guess when I read through the options, I myself was leaning towards option one for similar reasons as Councillor Armstrong just outlined. But I did have a couple of questions, and if I may, I'd like to ask those through you, Chair. One is, I noticed in option 3, there was a comment that should we choose that option, the city would be precluded from using the law, assuming it's a lawyer from a certain law firm, we'd be precluded from using that law firm for any other legal advice on other matters. And I didn't see that restriction under option 2, which I felt was a little bit, surprised me a little bit. And my second question, so I would ask Mr. Harding if he could in a moment to comment on that. My other question, if I may, is regarding the phone calls. I'm a little bit confused on this. Maybe Ms. Robertson can help me out. 3 phone calls per month, and it mentions that that could involve advice on conflict of interest, but at the same time in the report, it says if there's more sort of an in-depth conflict of interest situation, then we'd still need to go through our other procedure. So I'm confused about that, and I'm also not clear whether the 3 phone calls per month, would those be something that council would have to approve for a person to use one of those 3? How would that be monitored? So there's a couple of questions there, if I may.
Ms. Robertson?
I'm trying to remember what the other 2 were.
I'm sorry?
The phone calls.
All the questions. So the phone calls, sorry, I'm going back to, I'm getting the 3 of the questions mixed up together there. You wouldn't need council approval for the phone calls. This would be a way or an avenue for you as a council member. You're going, geez, I wonder if I have a conflict of interest. I'd like to be able to just phone and pick up the phone and ask the ethics commissioner, what do you think about this? And the ethics commissioner could provide you with some advice on that, or if you had some questions about the code. Where it gets beyond in the other processes, if, let's just say, you're talking to the ethics commissioner and the guidance is provided, and you say that he suggests, or she suggests that, yeah, you might be in a conflict, but then the individual council members decides to roll the dice and move forward. If it starts moving into a process, now somebody makes a complaint, you're now into the formal process. So think of those phone calls as, I just need a bit of advice, and you don't have to go through council to get that, whereas currently, under the council spending and amenities policy, we don't have that. That's not to say that you also couldn't do that with option 1. It would just be a separate process where you would need to amend that policy a little bit to account for that, if you wanted to pursue with having that phone call access.
All right, thank you. So if I may, to follow up, 2 things. Then what you're suggesting, Ms. Robertson, is that council need not necessarily know if individual councillors are taking advantage of those phone calls. And so we could get ourselves into a situation where we've used up our phone calls and we didn't know about it. And secondly, if I was to declare hypothetically a conflict of interest and excused myself and then went to get legal advice, instead of getting legal advice on that conflict of interest, would I be then allowed to simply contact the conflict or the integrity commissioner? That's, I guess, what I'm not sure of.
I think you lost me on that last comment.
So I declare a conflict of interest.
Okay.
I recuse myself. before I can re-enter any debate on that same topic, I need to get a legal opinion on whether or not I have conflict of interest. I'm sorry if I'm getting into the weeds here, but I guess what made me curious about this is instead of my having to get a legal opinion before I can re-enter the debate, could I simply phone the ethics commissioner for advice?
No.
Okay, that's good. That's all I wanted to know. And my other question, and I apologize, Chair, I should have taken these separately, to Mr. Harding regarding the restrictions on using the same law firm, which apparently is indicated in option 3 but not option 2. Could you just comment on that, please?
For Mr. Harding?
Yes, I can, Councillor Thorpe. Through you, Madam Chair, to Councillor Thorpe. Those are very good questions, Councillor Thorpe. Maybe I'll start with your conflict of interest one and comment a little bit further on that from what Ms. Robertson answered. I think I agree with Ms. Robertson's answer at the end, that the answer to that is no in the event that you were to engage with an ethics commissioner. Let's make sure we step back and understand the relationship between a council member and an ethics commissioner. Even if the ethics commissioner is a lawyer, they may be, they may not be. Chances are they will be, though. Remember that they're not in a solicitor-client relationship with you. They're in an ethics commissioner council member relationship, which is a very, shall we say, novel relationship in this province, particularly. So the ethics commissioner would not be technically giving you legal advice. They would be giving you guidance and probably the benefit of their experience with respect to conflict matters. Now, again, a caution, it's not always conflict that an elected official would necessarily be reaching out to an elected or to an ethics commissioner about. It could be other matters. There could be matters well outside conflict that you wish to talk with them about. But using conflict in the example that you set forward, you would always be entitled to seek independent legal advice despite what an ethics commissioner guided you on. It may be that it's very clear and obvious to both you and the ethics commissioner in your discussion that you should recuse yourself from a particular matter. But you are absolutely correct that after that discussion, if you wanted to go get independent advice, as the community charter allows you to clear up that conflict and then re-enter that discussion at a later point, you would certainly be entitled to do that. And the ethics commissioner would not be in a position to say, don't do it. Had you got some legal advice on that particular conflict that you raised with the ethics commissioner? So just please understand there's that distinction between the relationship that you would have with your ethics commissioner compared to a lawyer. It's very different. It's not based on privilege, and it's confidential, or at least it's intended to be, but it's not privileged. So that's a real big distinction you have to remember. Now, on your question around precluding legal work, I tend to agree with you that it's probably a matter of grayness between 2 and 3, and probably the same comment for option 2 would go with option 3 in regard to law firms that may be precluded from doing ethics commissioner work because they do a lot of corporate work for the city, whether it's through your planning department, governance work, whatever it may be. And I'll just tell you that there are some cases across Canada from jurisdictions that are more mature than ours in relation to the use of ethics commissioners, where there have been challenges brought to ethics commissioners doing work who held sort of dual portfolios with those local governments, where they did corporate work on one side, commissioner work on the other, and allegations of bias were actually made against the law firm. How can you have a solicitor-client privilege one day and then have an ethics commissioner relationship the next? And there was a successful case, I believe it's in Ontario, if I recall, that actually challenged the jurisdiction and bias of an ethics commissioner who was doing a lot of work, legal work, outside of that role. So that is why it's mentioned in Ms. Robertson's report. It's something that I've spoken with her about a couple times in preparation, and I do think that the city will need to look at that eventuality in the event when it's looking, if it chooses to look for an ethics commissioner on a more full-time basis. I don't mean full-time in the sense of a 1.0 FTE. That's not what I mean, but somebody who would be your ethics commissioner, an identified individual. You're going to have an internal discussion about whether that person can be that person because of their relationship with you otherwise. That conversation will have to take place. And so I'll leave it at that. I hope that answers your question, but it is a nuanced discussion that has to be had, for sure. I hope that helps.
Yes, it certainly does. Thank you very much. And again, I apologize for sort of taking us into the weeds on this, but your clarification is helpful.
No, they're very good questions, Councillor Thorpe.
Thank you. So a final comment, Chair, if I may. I also note in option number 1, the city solicitor could provide recommendations on third-party investigators should a complaint arise. And I guess I like the flexibility of option 1, and so I still at this point lean in that direction. Thank you.
Okay, thank you so much. And Councillor Armstrong.
Yeah, my question may be for Mr. Reach and Ms. Robertson. So who would determine which complaints from the public would be investigated? Because right now, some of them go to the ombudsman. Would they then be able to go to the ethics commissioner? Because a lot of the complaints are about ethical behaviors by councillors from outside parties other than council.
Through the chair, right now the scope of the bylaw does not include members of the public. Only council members, committee members, and staff are able to file a complaint.
So, okay, I struggle with that because I think one of the big issues is it should be from the public as well. Okay, thank you. I still am in favor of option 1.
Okay, thank you. We'll go to Councillor Kesselbrecht, but first, Ms. Robertson, you wanted to respond to Councillor Armstrong?
Yeah, and I think Reese could probably expand on this, but back when we were looking at the scope of the bylaw back last year, I think we cited in the report an example where it can derail the process. So Reese could speak to this, where in 1 month alone, they had 50 complaints from members of the public. So somebody who might be offended just watching the council show live, doesn't like a comment that's made, files a complaint.
Yes.
And you can be spending a tremendous amount of money and a tremendous amount of time following up on complaints from members of the public. And I can't remember the line that Reese used, but it was about what is the intent of the bylaw? And I don't know, Reese, if you wanted to comment any further on that.
Yeah, I'll jump in through you, Madam Chair, just to add to what Ms. Robertson has said. I don't think there were 50 complaints in 1 month. There were, as I recall, publicly stated 71 over the course of my time with the city of Surrey. I processed 71 complaints over about a 2.5-year period, and there was a moratorium in there as well. But the majority of those 71 complaints certainly came through residents, through members of the public making those complaints. And yes, the policy behind, and it's always council's determination and discretion to determine how far and how broad a code of conduct will be and who it will be available for. And what I think Ms. Robertson is referring to is some of the comments I made around who's the code designed for? Is it designed primarily for council members and staff, sort of internal to the city, to be dealing with more internal ethical conduct and governance concerns that arise? Or do you wish to open it up to residents, members of the public in some defined way? So in other words, it's an external document looking in as opposed to an internal document looking in. And that was a discussion that was had with Mayor and Council in an earlier public meeting that we had on your code some time back. This council chose in its wisdom to have it more of an internal document available. As Ms. Robertson said, complaints can only be lodged under our current code by council members themselves, committee members that are not elected, council members, of course, and staff. And staff is defined in a way to be inclusive of officers as well. So we have a somewhat limited scope of complaint in your code. And you are probably in the majority of codes that I've seen province-wide in that course. There are some municipalities that have chosen to open it up wider. Most, I think, still the majority have chosen to keep it relatively narrow with respect to where the complaints can arise from. So it's certainly a very legitimate policy choice for Mayor and Council to have made.
Okay, Councillor Kesselbrecht.
Thanks, Chair. Through you, just have a question. Like, in the ad hoc setup, council members or staff can make a complaint to, it's like an established firm, but does the CAO have to be involved to set up the contractor, provide some administrative support and direction, or is it hands-off?
Ms. Robertson?
Through the chair, the CAO would be hands-off.
Okay. Yeah, in terms of like choosing which one, I mean, just through initial read-through, I was drawn to the ad hoc There's two comments. There's one, if we have a set commissioner, there are relationships with counselors that are developed, and if things get really bad and the commissioner needs to start investigating counselors or do an investigation, having that prior established relationship might have some bias and make it difficult. That was one comment that was in there that made me think, oh, okay, why the ad hoc? There's some benefits to it. But I guess what I'm trying to sort through is, you know, given the situation a couple councils ago, what type of setup do we need to weather storms like that, where it's like the worst possible scenario and council, majority, and CAO are struggling, and you need accountability, and I haven't really quite sorted that through in my head, and so I'm curious other councillors' comments and staff.
So Ms. Gurry is going to try and answer that if you could. Thank you.
Thank you, Madam Chair. I just want to add a little bit to that as well, and some clarification for myself that maybe could add some clarification, because Councillor Manley had made a comment earlier. So with option 1, the ad hoc commissioner model, my understanding, and please clarify, Ms. Robertson or Mr. Harding, that a list of potential lawyers from a firm would be provided, and the CAO would have that option of choosing. So I see Mr. Harding nodding yes. So I think to Councillor Gesselbrock's question, that is something that would have been a concern possibly a couple terms ago. So that is something that, yes, if anybody else on council would like to comment on.
So just for clarity, the CAO would be involved in selecting representation there?
Yes, they would. My apologies. I thought you meant about the process itself, that they would be hands-off, but they would be the ones that would be selecting.
So in case you
individual would
have struggles with your CAO, that ad hoc model does have a little bit of a weakness to it in terms of having a full separation of involvement from the CAO. Am I correct?
Well, each of the the third-party investigators have that impartial, independent side to them. It would be a specific list of people who have the specific criteria. So I'm not sure how much influence the CAO would have on any one individual person on the list.
So the involvement in the CAO would be basically from a set list, it'd be like, go with this one. So
availability,
right,
when they can come, whether it's an in-person or by digital. I mean, a few things to be considered in there, but yeah, there's generally a list of individuals, and the city solicitor could help us.
Okay. I'm just curious in that
down.
process. I mean, does the CEO even have to be involved? Like, could you have the HR manager, another officer, be the one picking, or is there really not much room for funny business to happen in that particular scenario?
We certainly could. It's just the way the bylaw is written points to the CAO being that individual.
Yeah. I guess my question is this an area of weakness with this particular option?
I don't think so.
Maybe Mr. Harding, Ms. Curry, is it all right if Mr. Harding goes to answer this?
Yeah,
Mr.
yes,
Harding?
I'll defer to him, yeah.
Yeah, thank you, Madam Chair, through you. And certainly you don't have to defer to me, Ms. Curry. You've got lots of experience in these matters that equate with mine. So I'll add to your comments, not for deferral purposes at all. Councillor Gesselbrecht, let me address both of these issues. You mentioned sort of a downside of options 2 and 3, sort of relationship versus non-relationship, and you suggested that there sort of could be I think you used the word bias that might come into play in regard to a ethics commissioner that got to know members of council. I'm gonna push back on that slightly. I think there's pros and cons. I don't think it's quite that simple or quite that binary to say that just because somebody is more familiar with a group of elected officials that they become biased with respect to an investigation that they might have to do at some point in the process. I don't think it's quite that binary. Saying that from personal experience, I think it's quite possible for many professionals to have a relationship that is professional in nature with some elected officials, where you provide advisory and guidance assistance one day, where the next day you might have to actually process a complaint in relation to that person. Sometimes those relationships actually will be of assistance in the processing of the complaint if the relationships are based on some mutuality. And again, I'm speaking, I won't get into details, but I'm speaking from experience. I've had complaints that I've processed with individual elected officials that have been quite non-confrontational, frankly, and quite interesting in the way that they've sorted themselves out. So I don't think we should just conclude from council's perspective that just because you may have a singular ethics commissioner that they'll be incapable of processing complaints fairly, procedurally fair and procedural fairness, etc. I'm not so sure I'm with you on that. I see your point. I do get it. It is difficult for an individual sometimes to draw the distinction between a friendly conversation and then a more controversial or challenging scenario under an investigation. Your point is taken, but I just wanted to offer a different side of that equation for you to consider. In regard to the ad hoc side, the way that the bylaw is set up, when you don't have an ethics commissioner that's been appointed through the ethics commissioner establishment bylaw, is that the CAO will provide the complaint to somebody to process. That's the only role for the CAO in the current code. And that's set up on purpose to limit, as Ms. Robertson is 100% correct, the CAO has no role in the substantive processing at all, other than passing it off to somebody. Your point is a good point, though, to the extent, who are those people that you pass it off to? And I think what's being suggested here is that if you do go with option one and there is an ad hoc model that's created, that we would do sort of a pre-qualification list, if I could put it that way. Do sort of put it in the context of pre-qualifying some structural engineers on a short list that the city may use, or some architects that you have a particular degree of respect for. I think we would do the same thing. We would pre-qualify a number of people who we know are workplace experts, governance experts, perhaps conflict of interest experts. And it may be that it's a grouping of 3, 4, 5 individuals. And you would go to the correct individual at the time. You'd have to trust your CAO to do that, or in the event that the CAO was having some concern with that for perhaps personal reasons, if they were involved somehow, it would probably fall to Ms. Gurry's team. So it's not going to be just sort of a random, we'll go out and find somebody who we think is the best person to find. We'll pre-qualify these people. And you can also, if you want, create some policies in and around delegating the responsibility from your CAO for perhaps an external solicitor. So you could push that delegated responsibility over to somebody else to make the decision in concert with the CAO to find the right person, so that it isn't just left with the CAO's office if there's a concern historically that I appreciate what Mayor and Council are getting at here. I understand. So we could put some guardrails in place with respect to that, if I could put it that way, in option one. I'll leave it at that.
Can I have one more follow-up question? Yeah, I think just looking at the different setups, if the CAO is involved in the process, do they have the opportunity to delay or not forward complaints on, like if they're involved in a particular way? Are there some options that are weaker than others? And I guess that's my question, and potentially there needs to be more guardrails put up and other options that we go with. But I'm just thinking like worst case scenario, and I haven't fully flushed it all through, but that's just what I wanted to raise for, that we're considering. Thank you.
Thank you, Councillor Kesselbrook. Speakers in order are Mayor Krogh, Councillor Eastmore, Councillor Armstrong, and Councillor Brown.
Thank you, Chair. I was actually going to move option one. I think it's time we
Put something on the
everyone will have an opportunity, I'm sure. but
Okay,
if there's
moved
a
by Mayor
seconder.
Krogh and seconded by Councillor Hemmons. Mayor Krogh, did you wish to speak to it?
I do. This is an important position, obviously. I'm going to state the obvious, but you also have to ask yourself, what is the point of the position? I was trying to think of occupations or callings that were somewhat similar. I mean, is this person to be a priest for us, to provide moral guidance when necessary and ensure we know what we're doing and make us feel bad when we're being bad and good when we're being good? Is it a cop who's supposed to investigate our behaviors? Is it like a parent who's there all the time providing moral and ethical guidance, and you're stuck with them for the rest of your days? Is it a small town provincial court judge, and who you're likely to appear in front of every time you do something wrong, which I think brings with it a natural bias? It's for that and various other reasons. I think the concept of an ad hoc appointee is the appropriate one. I say this with no disrespect to the Law Society of British Columbia that monitors lawyers, but when I started practicing 43 years ago, come July the 10th, there were, I don't think, more than a dozen people. I could be wrong. Someone can question. Look, working at the Law Society of British Columbia, we now have a staff there, I believe, of upwards of 300. The legal population has maybe doubled or tripled since I started practicing, maybe even quadrupled. But my point is, offices like this tend to grow. Inevitably, they look for ways to justify what they're doing and providing more assistance than might be absolutely necessary. I mean, do you need 2 life preservers thrown when you're drowning? Will one be sufficient? And it just strikes me that without any experience, we're talking about potentially what I would see as the Cadillac model, when we could be having a Chev here. And I want to start with the Chev. And I say that very conscious of the fact that if the previous council had proper rules in place, etc., we wouldn't have had the previous council. We wouldn't have had these issues. But I, for one, think that this is not only sufficient, I think it will prove to be a good model. And it completely gets past that issue of familiarity that, and I'll call it familiarity, that Councillor Gesselbrock was raising. I think it's hard, and Mr. Harding is quite correct. People can get past it. Judges hear from various lawyers with different styles and reputations all the time, and yet they adjudicate the cases in front of them appropriately. Having said that, I think the ad hoc approach would avoid how one would feel if they had been the subject of a complaint during their time in council and been sanctioned for it, and then another complaint comes forward and it goes to the same person to adjudicate it, if you will, or come to a conclusion. I think that would leave a rather uncomfortable feeling about the whole process, and you would avoid that by having an ad hoc person. So I'm solidly in favor of option 1. Thank you.
Okay. Councillor Eastmore, then Armstrong and Brown.
Thank you. I have a question about the ad hoc process, and I think Mayor Krogh sort of brought it up right there when you said whether it would go to the same person. Is there a gold standard around using the ad hoc model where it always goes to someone different, or would it go to whoever is best qualified on this pre-qualified list that we might have, which I thought was interesting, and I would be interested in setting up some of those guardrails that Mr. Harding referred to.
Who would like to answer that? Ms. Robertson? Or Mr. Harding?
I can give that a try, Madam Chair, to the councillor. I think, to be very honest, councillor, it will really depend on the nature of the complaint that comes in. If the complaint, as we talked about before, if you had a pre-qualified list of individuals who would act in the role as your ad hoc commissioner for whichever complaint came in, if 2 complaints in a row came in on procedure bylaw concerns, it may be that you want to go to the same ad hoc investigator two times in a row because that's their expertise. So I think it's hard to predict exactly where it will go, but I think the intent behind it is to go to the person who has 1, the expertise, 2, the time, and 3, I think it's been mentioned in a number of different places in this conversation, some economies as well. There's going to be some economies that you want to take into account here. For a relatively simple complaint, you may be able to go to a relatively junior investigator as compared to something very complex where you might want to go to somebody more senior. Thus, the complaint will be let's just be direct about it, cheaper to process than it would be otherwise. So I don't think we can have a predictive model here on where it goes, but I think the intent behind it is to make sure that you put the work into the silo of the ad hoc that is most and best equipped to manage the complaint. There has to be some trust with the person who is moving that work to the appropriate place.
Councillor Eastmore?
Yeah, so there has to be some trust in the person who's moving that to the appropriate place. That's a potential sticking point for me, given some of the things our city has experienced. And I just wonder, like, if a decision's made by the ethics commissioner ad hoc who's appointed for that particular case, if it's an unpopular decision and then a similar issue comes up, what's to, like, is there a mechanism? I just wonder, like, would then someone be deciding to go to someone else because the last decision was unpopular, Ms. Gurry?
Yes, sorry, Ms. Gurry.
That's okay. Thank you, Madam Chair. Just a couple of points to Councillor Eastmere's questions and what Mr. Harding said. So a couple things about whether it's the CAO position or the corporate officer position. There are a few officer positions at the City of Nanaimo, and we all have a duty that's above and beyond that to the CAO. It's to the actual organization. And there's also provisions in the community charter that don't allow interference with those positions. As well, I think that there's a lot of honorable CAOs out there and corporate officers out there that we wouldn't, if this wouldn't even be an issue. So just looking to our future, our current CAO or future CAO, none of this would be an issue, I don't believe. But having said that, there are positions within the city that exist and will continue to exist that do have that duty. And we do in these roles have to make those decisions, whether we are in a relationship and have developed relationships with you over the years. We do have to make those calls that are best for the organization and meet the legislation. So that's just one of the things I want to say. So I don't want to overdo this too much, but I think that there would be legitimate criteria, like Mr. Harding was saying, for those complaints that would need to be handled, that you could have the CAO or somebody else in the organization meet. But ultimately, any complaints that happen, any complaints that are investigated by the ethics commissioner, whether ad hoc, permanent, whatever, ultimately it's council's decision. So council's decision to hear these recommendations and then decide upon them. So it's not the ethics commissioner making the decision, it's not the CAO making the decision, it actually comes to council. So you have the ultimate say. So the control and the mechanisms that help, that work before that process ultimately comes to you for a decision. So you ultimately do have the final say. So that's something that I don't know if that gives you comfort, but, and or if Mr. Harding has anything further to add to that.
Mr. Harding, did you want to comment?
Yeah, thank you, Madam Chair. I agree with everything Ms. Gurry said. I think that's a really good synopsis of a number of points to weave into your thinking here, to all the mayor and council. I think she's made some very valuable points. I'll just add on to that again by saying this, and the mayor's made a very logical and a straightforward suggestion that the ad hoc process is better, and the priest versus cop versus parent versus judge analogy is a very good analogy and a very good way to look at it. And so the mayor's made the position on option one being the better of the two. I will just say this by way of experience to all of mayor and council: neither of these options are perfect. They're just not. And I think that's the reality. Probably everybody recognizes that through this conversation. And there is a tension and a push and pull in option two between having a permanent person who you get to know and then being investigated by the next day. That there is a tension there. There's also going to be a tension perhaps on option one, that there might be some hesitation that someone else other than the commissioner, someone independent, removed from the situation, will have to make a decision leading to who that investigator is. So there's no perfect process here. And I think, you know, I would encourage mayor and council to think about what's best for your city in the circumstances. What will be best? Somebody who you can work with, who you've had a pre-qualified list that you can go to. And I also want to make another point on this. Just because you go with option one doesn't mean that you can't have the benefit of ongoing governance seminars and ongoing educational stuff as a group. You can. You can decide who you want that with. You could have lawyer A on conflict, lawyer B on gifting, lawyer C on procedure bylaw, whatever it may be. You can choose, you can customize. And frankly, a good ethics commissioner would customize who those people were too. They don't have to be the ones speaking to mayor and council all the time. Get somebody in who has more professional experience on conflict resolution than they do. So I don't want you to think again that these are binary choices. If you go with one, you throw out all the benefits of two. You don't. You get many of the benefits of two, option 2 or 3 in one, and vice versa. So the other thing too is this doesn't have to be a permanent choice. If you find it's working fantastically well, and the budget's going well and everything is happening, and option 1 is working great. If we find in a year that it's not working so well, we can always come back and revisit this. So it's not a permanent choice. Is my point in that regard. We watch these bylaws evolve. It's likely that Ms. Robertson and I will be suggesting some amendments to your code of conduct within the next calendar year to actually bring it into better practices. We'll always evolve these offices. So we're not stuck with anything is my point.
Ms. Robertson, did you want to add a comment? You had your hand up towards
It
Councillor
was
Smith?
just- just pertinent to that. I think, I just wanted to add that no matter whether it's ad hoc or an appointed commissioner, you have to follow the Code of Conduct bylaw, and there is a very specific complaint and resolution procedure set out in Section 4. And even towards the end of it, it states very specifically, no council member, committee member, or staff will obstruct the commissioner in the carrying out of their duties. They will not threaten or undertake any active reprisal against the complainant. It goes on to say, and also if you are found to have engaged in any reprisal or retaliation or violation, you'll be subject to the appropriate disciplinary action. And for staff, that could include up to dismissal. So there's, no matter who is selected, you still have to follow those procedures that are in there.
Can we
That's
move?
all I wanted to add.
Any final comments?
Yeah, I really appreciate that clarification, and this is not coming from any lack of faith in staff and our officers' abilities at all. It just purely for my own understanding of the processes and the potential pitfalls and opportunities. So thank you so much.
Councillor Eastmore, it's good to ask the question, so that's great. Councillor Armstrong.
Thank you. The mayor said a lot of I said, and I think the other thing when, and I'm pretty cognizant that I have to be really careful what's being said because there's 3 outstanding legal options against the city right now. So we have to be careful on some of our words. But you also have to remember, we're talking about ethics, not respectful workplace. There's a big difference. And a lot of what other councils have been referring to are respectful workplace, which would not fall under the ethics. And my second point is, I don't know why we would spend like $100 and some thousand because we're going to have to put those people on retainer for either option 2 or 3 when we haven't had any situations in 6 years. So why, to me, it's a waste of taxpayers' dollars. I'd much prefer to start with option 1. If it starts to look like we're going to spend over that, then that's when we start to look at other options. So again, I'm still in support of option 1. Thank you.
Okay, just before we go to Councillor Brown, Ms. Gurry wanted to add some comments?
Yes, thank you, Madam Chair. Just some clarification through to Councillor Armstrong. We wouldn't be putting them on retainer. It would be just paid as issue. There would be one specific person in options 2 or 3, but they would only be paid if and when an investigation would need to occur. And right now, within our current legal budget, we had reduced it for this year. We're suggesting to increase it by about $50,000 next year and just create a line that's specific to this purpose, though it does not all need to be spent. We wouldn't be for sure spending this amount every year. We would spend only as a complaint came in.
Could I have some clarification? Because my understanding is if you want to keep a firm like that on it, you must pay a retainer first. Perhaps Mr. Harding could speak to that.
Mr. Harding?
Be a little bit careful what I say because of some of the commercial niceties around this, but my experience with this is that there and certainly I can speak for my firm with respect to the city of Surrey. We did not have a retainer. It was not a monthly retainer. It was as time was needed. Whatever time was needed was what the municipality engaged with. So, and Councillor Armstrong, to your point, I'm not saying that there can't be a retainer. Of course there could be, and that may be a requirement of a specific law firm. They may want a retainer if you're going to tie up their time and take them away for other things. But only speaking for myself and my experience, I've not seen retainers, direct retainers in the standard way we understand them. Pay X dollars to have somebody standing by for you, and if the time's used or not, you lose the retainer. I haven't seen that so far in ethics commissioners' models in BC. I'm not saying couldn't happen, but it might.
Thanks.
Thank you for your patience. Councillor Brown, it's your turn.
Thank you. Thank you, Chair Perino. And I have one question, and then I think based on the answer to that question, will sort of solidify my comment. So if that's okay with you, I can do it all at once. My question would be through to either Ms. Gary or Ms. Robertson or Mr. Harding, or maybe all three. I'm having a little bit trouble understanding process-wise the ad hoc. So let's say a staff member has an issue of concern, or a council member. Do they bring that to the CAO, who then hires, proceeds with hiring of the commissioner for that particular item? And part two of that is the CAO just automatically do that no matter what comes in, or is there a filter in there that weighs whether it's something worthy of hiring the commissioner?
Ms. Robertson?
The ethics commissioner or the ad hoc commissioner would be the person to oversee any informal or formal complaint. So yes, as I envision how the process would work, if a staff person had a complaint, they would go to the CAO, and the CAO in the ad hoc model would then work with somebody from the list that would be qualified to look into it. But they would look into it whether it's informal or formal, and they would kind of vet it and possibly come up with some preliminary recommendations as to how to solve the matter informally before it proceeded down the formal path. But CAO to whoever is selected.
Councillor Brown?
Thank you. Thank you, Chair. And I appreciate that, Ms. Robertson. So, Mr. Harding had his
Mr.
hand
Harding's
up there.
actually got his hand up. Do you want to?
Yeah.
Yeah, Mr. Harding?
Yeah, through you, Madam Chair, to Councillor Brown, I just draw your attention to a couple provisions of both the Ethics Commissioner, the two bylaws that Council passed last year. So the Ethics Commissioner bylaw and the Code of Conduct, you kind of have to read the two together. So in Section 5.1 of the Ethics Commissioner bylaw, it's entitled Ad Hoc Commissioner, and it says this, and this is where this discussion is generating from. It says this, it says the CAO may hire an ad hoc commissioner to carry out one or more of the following duties set out in the bylaw or in the Code of Conduct in the following circumstances. And the one we're talking about is A, if the city has not yet entered into a contract for the appointment of an ethics commissioner. So the CAO is given the authority to hire those ad hoc commissioners in 5.1, but when you go to the code itself, you go to 4.1.2, that's where the complaint procedure starts. And it says straight up, any council member, committee member, or staff may submit a complaint to the commissioner. So it doesn't go to the CAO, it goes to the commissioner. But what I'm suggesting here by way of process is that your CAO under 5.1 would have a vetted, pre-qualified set of individuals who are technically the commissioner as defined under the code. And when that complaint comes in, it would automatically be sent, probably through the corporate officer or through the CAO's office, directly to the selected commissioner from the list of 2, 3, 4, 5 individuals who are pre-selected by the city. So that's how I envision the process from happening. There'll have to be a piece of paper or a digital record that moves from the city to the commissioner, but that commissioner is already there as set out by the authority given to your CAO under the Ethics Commissioner bylaw for interim commissioners. So that's how it would work.
Okay, so thank you for that. And again, though, point of clarity, what does that submission look like to the CAO, right? Is it, I have an item that I want to speak with the commissioner about, and in general terms, it's related to this, or is there details?
Well, again, the bylaw answers that because the complaint is set out. What it looks like is at 4.1.2. B, and a complaint must be in writing and must have sufficient detail, 1, 2, 3, 4, 5, 6, 7. So there's detail with respect to that, but that is not analyzed or looked at by the CAO in any way. It would be passed on to the commissioner for their look at it, and then their assessments of the preliminary assessment process under the code, etc. There's a lot of different off-ramps that would then be employed by the commissioner in looking at the complaint itself. So the CAO would not be involved in any way on administering or substantively reviewing that complaint. They would simply be, I'm going to use this word, administratively forward it to the right person. They don't have any role in the bylaw, the Code of Conduct bylaw, for analyzing it, reviewing it, administering it. It's simply, it's almost clerical, if I could put it that way. And I don't mean that in a derogatory way. It's like a clerical process.
Councillor Brown?
Thank you, Mr. Harding, and thank you, Chair. So based on all the information and the discussion, I would have to say that after hearing the discussion, my mind has not changed. I don't think option one is the correct approach. My preference would be option two, so I will be voting against this motion. And my reasons for doing it are born a little bit out of my experience from chairs the RDN and stepping in on complaints that there didn't necessarily fall completely under a respectful workplace. Some of it did. Some of it would be moving more towards these conversations around ethics. And I think having a clear process such as that would occur through option two that is just sort of independent or a little bit of a lot of the players would be very useful in getting to a better conclusion or a better outcome. Secondly, I would say I think familiarity is actually important. Not I wouldn't necessarily call it bias, and I appreciate his worship using the term familiarity. I think that's very useful to sort of understand, sometimes understanding how certain threads came to be, and providing again a path forward that a lack of familiarity might produce a worse outcome. And I think thirdly, looking to history and also looking at the best structure, I don't think option one provides the necessary checks and balances. I think in theory they exist, and just based on previous experience at the city, in theory the checks and balances existed then as well, but they didn't work. They weren't strong enough to I think a level that would be acceptable um, to the general public, to what council's expectation should be, and also provide a framework in which councillors or staff that are put in difficult circumstances have a clean path forward towards an acceptable resolution. So I think taking the sum of all those three items for me, I think outcome one looks good in good times. Or sorry, I think option one looks good in good times, but I don't think it's structurally strong enough to support the people that it needs to support during difficult times or difficult conversations. And so for that, I'll be voting against this motion. I really hope actually council will as well and go with option two, in hopes that we never have to use this money this term or the next or for any other term for that matter. But in the event that we do, that a sound structure exists, it's going to protect council members, it's going to protect staff, and it's going to hopefully move any sort of tension to a really good or a better outcome that can exist in this situation. Thank you.
Thank you, Councillor Brown. We've been at this for over an hour. We have two more speakers, Councillor Gesselbrook and Councillor Hammonds, and then I'm hoping we can come to a decision. Councillor Gesselbrook?
Thanks. Yeah, just hearing what Councillor Brown's saying and sort of my feelings of seems to be a little bit of weakness and accountability on option one, just with the role of the CAO in it. I would say that option two probably does provide a little bit more robustness of a process, and I think it might be a little bit more expensive, but I think in the long run, for peace of mind of not running into an issue where we had a few councils ago, that it's probably worth it. So thank you.
Thank you so much. And next is Councillor Hammonds and then Councillor Thorpe, because he's been so good to help me with this machine. Councillor Hammonds.
Thank you, Chair. I supported the motion and I'm inclined to support it in a vote. I'm curious though, based on Councillor Brown's concerns, I just would like clarification from Mr. Harding. What I understand the sticking point might be is that if we have an ethically compromised CAO, that option one means that whoever is lodging the complaint could be, that could not get through to the appropriate channels to be investigated. I heard you say, Mr. Harding, that it's essentially a clerical duty, and I understand that's not a diminutive term, but it's simply a forwarding of the complaint. So can I just have some comment on that? The concern is that it could stop at the CAO, but I'm hearing Mr. Harding say that that's unlikely. So just further comment on that, please.
Through you, Madam Chair, I'll do what I can for you, Councillor. I'm not, again, sure that there's an answer to this from the perspective of our starting point. I'm going to start from a point, given the current mayor and council and given the current senior management team, along the lines of what I heard Ms. Gurry say, is that you have an ethical, principled senior management team in this organization, along with an ethical and principled mayor and council. So I'm starting from that foundation, not the opposite. And I see very little objective room in the way that we've designed the bylaw and the code for the CAO in and of itself to be interfering with an investigation. There's very little room for it in the way that the bylaw has been drafted. As I mentioned, the place where the decision will occur on an ad hoc system is who are you going to pre-qualify? So is there an opportunity there for there to be some form of favoritism, some form of creation of the list that may not be to council's liking? Let's be very direct. Of course, there's a small risk there, but I don't see that as a substantial risk. I think that there are good people, good investigators, and good lawyers involved in this circumstance, which will lead to a robust creation of an ad hoc list if mayor and council's wisdom is to go with option one. I'm certainly not worried about that list being created in a way that puts concerns into the hands of how the complaint gets from A to B, which again I would describe as a near clerical process under the way that the system is currently designed. So I'm starting from a place of accepting that people are approaching this with a degree of good faith and honesty, and I think that's appropriate in the circumstances of the city of Nanaimo in today's time.
Thank you.
Councillor Hemmens, thank you. Councillor Thorpe.
Thank you, Chair. I appreciate your indulgence. Actually, between Councillor Hemmens and Mr. Harding, I think what I wanted to say has largely been covered. First of all, as Mr. Harding pointed out, none of these options is ever going to be perfect. Second, there was a comment made about checks and balances, and I think those were not always in place. But with this bylaw, I feel that they are now in place. And Mr. Harding has referenced 4.1.2, which I think is really crucial because I've sensed around the table today a concern that hypothetically a CAO could block the forwarding of complaints. And that is not the case. And I see that under 4.1.2. So I don't think that is a valid concern. I don't think we need option 2 or 3. In my mind, still option 1 provides the most flexibility and I think is best for our needs. Thank you.
Thank you, Councillor Thorpe. Councillor Brown, I know, have you got something new to add?
No, Chair, but I do think it's hard. I just want to try to provide clarity
Sure.
in my comments. My concern is not that the CAO would block. I think the process is outlined the way it is to avoid that. But I think you have put himself in the very practical circumstance of a staff member that wants to bring forward an ethics complaint through a CAO that they believe is ethically compromised is problematic for the same reasons that we've developed a whistleblower policy. That it might not be the complaint that's blocked, but it's information, and it's information that can be weaponized in other ways. I think that's highly important to consider when you're looking at all our policies and how they fit together and the type of culture that we're trying to create and protect. Thank you.
Thank you. Okay, if there are no other comments, I'll just add my own. I certainly, similar to what Councillor Brown said about, past experience, and that is always what, frames your decision-making. And I agree, I've very rarely seen a situation that couldn't be handled. And that's why I'll be voting for option 1. I think that we can always go back and take a look at the other options if we need to, but it allows us the freedom to make the decisions about who we pick. And we haven't had anything come up in really years, and certainly nothing since the bylaw first came forward. So I'm thinking, I think we just over-worry. So I'll be voting in favor of option 1. So I'm going to call the vote now. The motion is for option number 1. All those in favor, please. Councillor Hemmens, Councillor Thorpe, Councillor Perino, and Mayor Krogh. Those. Oh, and Councillor Armstrong, would you like to vote? Are you voting in favor or against? Councillor Armstrong?
Yes, I'm voting in favor. You called the question, so I'm voting in favor.
1, 2, 3, 4, 5, 6, sorry, and also Councillor Eastmore. Those opposed? Those opposed? Councillors Gesselbruck, Manley, and Brown. Motion is carried. Thank you so much. Next report, Ms. Gurry? Yes.
Yes, Madam Chair, just before, even before Mr. Harding leaves, I just want to thank both him and Ms. Robertson for all of their work through this and walking you through this several times now, previous council and this council, and to note that I won't be here at the end of August. I'll be on vacation, hopefully, but Ms. Robertson has announced her retirement. So I just want to take this opportunity while she's here and with this great body of work she's just presented to thank her for all of her hard work that she's done while she's been here and throughout her career. I admire her. She's been a mentor to me. She's been an amazing colleague, and I'm going to greatly miss her, and I know we all will because of the great amount of work with bylaws, with policies. She's just got an amazing work ethic and has created amazing amounts of work.
Ms. Curry, I have to just stop you. Now, you're saying Ms. Robinson is actually retiring?
She's actually retired.
When is she retiring?
She has 2 dates.
Are you serious?
She likes to keep us on her toes.
Mayor Crow, did you allow this, really?
I know, right? I barely did. So July 7th, which is just the end of next week, is her first date. Then she has some time to use up before she's graciously said she'd come back and cover my vacation in August. So she'll be done August 31st.
Wow.
So,
Better. That's good. That's good. We need to have you here.
Thank you for
Thank you so
indulging me,
much.
Chair.
Thank you. And Mr. Harding, thank you so much. Did you want to add any final comments before we go on?
I just wanted to say it's been a pleasure to work with you too, Karen. We've had lots of time together on this file, so thank you for your leadership on it and for involving me. It's much appreciated. I wish you all the best.
She's going to have way too much fun, I know it. Thank you so much. All right, we're going to move on to the second report, Prosperous Nanaimo, and this is being introduced by Mr. Lindsay. Thank you so much.
Thank you, Madam Chair. I'm going to turn over immediately to Ms. Bhopal Singh, who can start us off this afternoon.
Perfect.
Good afternoon, Council. So we are pleased to return to you today with the culmination of all your hard work over the last few GPCs with a final draft of the Integrated Action Plan for your consideration. And before I turn it over to Ms. Begun to walk us through some of the directions that you've given us that result in this document you have today, just wanted to remind maybe members of the public and yourselves about how this document's intended to work. So a key piece of this document is this gives us basically your playbook for us over this remainder of this term about what your priorities are, as well as other actions to implement city plan. I also wanted to point out that by doing this work, you are taking a huge leap forward in one of the 6 priority focus areas you've identified in your strategic plan, which is implementing city plan and developing action plans to do this. And this is an integrated action plan instead of what typically happens in most local governments is each department goes away and does their own action plan and tells council how they're going to implement their priorities. This is one integrated document. And by having this first cut in place that gets reviewed each time you come up with your budget decisions, it means that as departments, we work collaboratively to ensure that we are doing the best to efficiently and effectively implement the different actions that you want to see us take. So I thought I'd just point that out and also thank you for the work that you've done with us to get us to today. So with that, over to Ms. Beacon.
I was going to say,
I don't
something I
sit in
need
this
to turn
chair.
on here?
It's different for me. Okay. Good morning, or good afternoon, everybody. Nice to see everyone again. So I am here to present, yes, our revised version. All right, we'll move on to the next slide. So the purpose. So the Integrated Action Plan is a supporting document to City Plan, as Ms. Bhopal just mentioned. And the purpose of this document is to communicate the full breadth of the actions the City of Nanaimo may consider undertaking in the ongoing short and long term. As a reminder, these actions are drawn from 40+ documents of previously endorsed and adopted plans, in addition to new actions to support the implementation of City Plan. And all these actions are now housed under one document, this document. And there's extra copies in the back for those councillors that would like a copy. And this one document will support the integration and interdepartmental communication, as well as leverage opportunity, efficient investment, and maximize community benefit. So between March and May of 2023, staff presented the draft integrated action plan and draft priority action list to the Governance Priority Committee. These meetings were an opportunity for the committee to provide feedback on the draft priority actions for the 5 city plan goals and city structure. Through the use of Zoom polls, the committee members were asked to identify which actions to prioritize over the next 4 years. And committee members were also offered an opportunity to bring forward additional actions, which took place. And then on June 12th, the top 3 priorities identified by neighborhood associations were brought forward to the committee for consideration and inclusion in the integrated action plan. This slide represents a summary of the changes made as a result of the spring GPCs. So in addition to the committee's changes, which are outlined on the slide, the 2023 Neighborhood Association Priority List actions were added as an appendix, as well as general housekeeping changes were made to improve accuracy and clarity of the document. Staff have incorporated all these changes into the final draft presented to you today. All right, so in total, the committee identified 203 priority actions. It will be at council's discretion which actions to consider for inclusion in the city's annual capital plans, budget, and department plans, as Ms. Bolpolsing pointed out. So through annual budgeting, the integrated action plan will be used as a guiding document for council to consider resource allocation and to strategically support priority actions. The priority actions are in addition to regular and ongoing functions and services and programs the city already provides. Lastly, I want to emphasize that the integrated action plan is intended to be a living document that can be updated on an ongoing basis. New actions could be added, adjusted, or removed that have been achieved, become outdated, or have been superseded. The flexibility built into this document is to account for new knowledge and direction from council or planning processes. So the recommendation in front of you today is that council endorse the revised integrated action plan and use the information to guide and inform annual budget considerations. And to wrap up, in terms of next steps, so we're going to bring forward complete key indicator assessments and metric development and provide council with a draft monitoring strategy in the fall of 2023. Thank you.
Okay. And ready for questions?
Ready for questions.
Are there any questions? There is a motion if you prefer. Council? Council Kesselbrook?
Thanks, Chair. I just want to say great work. This is a culmination of a lot of effort, and I think that a pretty robust process has been established, and there's probably a lot of little kinks and things to tweak, but I think once the monitoring strategy is done, there's a very solid logical process that's been put in place, and having that integrate into the annual budgeting cycle, I think, is the next big step. But at the outset of this, I think we talked a lot about coherence and building a coherent process for the city to set a vision, a means of measuring it, and then breaking that down into concrete action. And I think that's been accomplished. And so I know there's a lot of interest in other jurisdictions of what was created here, and I think now proof will be in the pudding. Is this an effective way for a city to organize itself, and does it allow for transparency and accountability from the community? And I really look forward, and I just got to commend staff for taking a bit of a risk, but a leap, and having faith in council as well to try this out. And congrats on a lot of work that's been put in place, and I definitely fully support what has been created here. Thank you.
Thank you so much. Councillor Eastmere?
Thank you. Thank you so much to staff for putting this together. It was, it's a hefty document for sure, and going through it was really interesting, and it's basically our wish list of all the policies and things we would like to see done. So I love having this to work from. I did note that there's quite a few pages that are like essentially blank pages because they're like the future or ongoing immediate project lists where it just says no project actions currently identified for this timeline. And I did have a little bit of discomfort with reading those pages because it makes me feel like we're not thinking about those things, and that's where I think the fact that it's a living document comes in and is a really important piece of this, and we don't want to just put this on a shelf and like never look at it again. We need to constantly be looking at it, and I would love to see maybe some discussions planned where we look at those empty spots and try to figure out what we can put into there, because as a member of the public reading this, I might go, well, they don't have any ideas about what they want to do for the future of this program, and there's a lot that can be incorporated. So yeah, my comment would be if anyone is feeling squeamish about seeing those empty things, like, yeah, it's a work in progress, and this is just an amazing way to capture what we've been talking about so far, but there's a lot more work to be done on that. So thank you.
Thank you, Councillor Eastmere. And the wish of council, please.
I'll move the recommended motion.
Moved the recommended motion. Is that second? Second, Councillor Manley. And
I do have a specific question, actually.
hold on, let me just, okay, I'll let you speak to the motion first of all as moved, and then I'll let you speak to it as seconded.
Thank you, Chair. Yeah, I was happy to move this motion for all of the reasons given. This is a great piece of work. I focused on the prosperous section, and I just want to note that, pardon me, I've got several documents open here. 173 through 175, I believe, are all in reference to the donut economic framework, but 173 and 174 don't actually reference that. So we might want to add some language in there, just because taken as standalone sentences, they didn't make sense to me.
So through the chair,
yes,
we can make that amendment. Yes,
please.
Of course. Thank you for the clarity.
Okay. Thank you, Councillor Hammonds. Councillor Manley.
Thank you, Chair. Yeah, I just wanted to thank staff for this document. I really appreciate the maps in it to show the distribution of work that's being done in the city. It kind of gives a real breadth and scope of all the different projects that the city's engaged in, and that we're seeing the community as a whole and really making sure that we distribute the work evenly throughout the community. So just wanted to thank staff for this and really appreciate it. Thank you.
Thank you, Councillor Manley. Any other comments? I'll call for the, sorry, Ms. Paul-Singh. Yes.
Through the chair to the committee, I think we need a motion to just amend 172 through to 173, just for clarity, so we have that.
So, Councillor Hammonds, I'm sorry, can you just repeat what you just said, Ms. Paul?
Madam Chair, I think that if Councillor Hammonds would like to amend the motion that's on the floor right now to make those changes and have that seconded, we could then do it all together like that.
The first motion was seconded. Does that matter?
Yes, it does, because now this is a formal amendment, if she was going to make that formal amendment.
Yeah, my apologies, I did that really backwards. So I'd like to move an amendment that staff integrate the language around the donut economic framework in policies 173 through policies 175.
And then we would need that seconded.
I hear you say that you second that.
Okay.
So we're voting on the amendment first.
That's correct.
Any other comments to the amendment?
Ms. Beacon?
Through the chair, just for clarity, you're speaking to the actions, not policies, correct?
Yes.
Okay, just to confirm. Thank you.
Okay. Speaking to the amendment, all those in favor? Anyone opposed? Councillor Thorpe is opposed. It carries. I'm sorry, Councillor Armstrong.
I'm opposed.
Thank you so much. Councillor Armstrong and Councillor Thorpe are opposed. Thank you. We will have this passed then, and the main motion, this goes as part of it.
So now you would vote on the main motion as amended, because the amendment did pass.
voting on the motion as amended. No other comments? All those in favor? Opposed? Councillor Thorpe and Councillor Armstrong, motion carries. Thank you so much. Are there any questions from the gallery? There's no other work. If we could have a motion for adjournment, please. Councillor Kesselbrook, second. Councillor Hemmons, all those in favor?